Good afternoon, everyone. We have about a minute, so we will get started right at 12 o'clock. Great. It's 12 o'clock. So good afternoon. Welcome to Vancity's estate planning webinar. My name is Kristen Schreckenbach, and I'll be introducing our speakers. But before I do that, I'd like to begin by acknowledging that Vancity operates on the unceded lands of the Coast Salish people represented today by the Musqueam, Squamish, and Tsleil-Waututh nations. They have been custodians of this land since time immemorial, and as visitors, we would like to start this webinar by paying our respects to the elders of past, the present, and emerging. Some of you may not know, November is Financial Literacy Month, and in support of this, we are hosting a series of webinars each week during this month. So we're inviting all of you to register for the other webinars that we're hosting. Before we begin, I just want to go through some housekeeping items. This webinar will be recorded and shared with the registered attendees. It will also be posted on our YouTube channel, so please follow us. As such, we have turned off incoming cameras and muted your microphones. If you haven't already, please make sure you follow us on YouTube, a little bit of a plug, and our various social media platforms like Instagram to stay connected to get access to great content like this webinar. For those of you already joining via desktop, please note that at the banner of the top of your screen, you will find opportunities to engage with us, especially the Q&A button. That allows you to submit your question, and we will answer those questions in the Q&A portion of this webinar. Lastly, we encourage you to engage with us throughout the webinar and take note of what's most valuable and what would be most helpful for you. With that, I'd like to introduce our speakers for this webinar today. Linda Deer has a law degree from UBC and over 30 years of experience of will and estate, including at Vancity, the public guardian and trustee, as well as at a Vancouver law firm. Not only can Linda provide financial literacy with wills and estates, she also gives advice on choosing an executor, recommends documents to protect you and your family, and a lawyer that will help you get started on the right path. Our other speaker today is Mark Braeder. He has personal services practice, providing sophisticated legal advice to individuals and small businesses. Mark has extensive experience in a wide range of transactions and contexts. He focuses on wills and estates, real estate, business, and corporate commercial law. Mark's wills and estates practice ranges from simple wills and power of attorney to complex corporate reorganizations, trusts, and estate administration. Mark is a frequent lecturer about wills and estate planning, so we are very lucky to have him here today. So without further ado, I will pass this time to Linda to say a few words.
Great. Thank you, Kristen. I'm glad to be back doing this estate planning webinar during Financial Literacy Month for 2022. It's been a while since we've done this. And hi, Mark. It's nice to see you face to face again.
You too.
Thanks for presenting this topic today. It's a really important topic and a major part of overall financial planning for everyone, regardless of age or financial status. So it's great that you're here to help today. So our big picture goal today is to answer the question, how do you protect yourself and your family in the event of death, serious injury, illness, disability, or incapacity? I know not things that we want to talk about, but important nevertheless. So there can be a lot to take in on the topic of estate planning, and we don't have a lot of time to cover everything in detail. But the basics that will be covered will definitely help most people start by putting a simple plan together to protect them, their families, and their assets. Before we begin, just a reminder that if questions do come up, please record them in the Q&A section of the screen so that our moderators can pick them up and bring them to our attention at the end of the presentation. Thank you. So Mark, I speak with members about estate planning every day. And in order not to overwhelm people right off the bat, I usually try to summarize the essence of estate planning in just 1 to 2 sentences. Is that something that works for you as well?
I've never been tasked to do that, but basically estate planning is just making sure that all of your affairs are set up properly so that your assets can go where you want them to go when you pass away, and your kids are taken care of, and you pay as little as you can to the government.
Yeah, right. So there's 2 aspects, what happens after you die, and also what happens if there's potential incapacity or illness during your lifetime. So those are the 2 areas we usually look at. And the 3 main documents that we talk about are the will, the power of attorney, and the representation agreement. Those things cover off most things for most people. So that's usually where I start. And I find that when we talk to people, the term estate planning usually brings up the thoughts of wills and what happens after death. So Mark, you'll be starting with that right now. So take it away.
Great. So if you can pull up the slides here. I assume everybody can see it because I can see it. So we're going to jump right in and talk about what your will is. So your will is just a document made by you that it takes effect on your death that gives instructions about how your assets are dealt with and divided among the persons you name as beneficiaries. Why is it important to have? The purpose of a will is to outline your wishes. Everyone needs a will, but over half of Canadians don't have one. It doesn't matter if you're rich or poor, married or single, everyone needs a will. If you die without a will, you'll have no say in how your assets are dealt with. You have no say in who will raise your kids if you die. So a will allows you to appoint someone to deal with everything when you die. That's called your executor. It allows you to appoint a guardian for your children. It allows you to select who you want to inherit your assets. Otherwise, the government decides. And nobody wants that, except for one client I had once who made a will leaving everything to the government as long as they didn't use it for education or healthcare. So there's always the exception that proves the rule. Your will also allows you to ensure that your beneficiaries receive your inheritance how and when you want them to. It also can allow you to take advantage of certain tax savings, and it can help reduce the cost of administering your estate. The next slide, please. So generally, to make a will, you just have to fulfill 2 criteria. You have to be over the age of 16, unless you're on active duty in the military. It seems like a pretty weird condition to have to be put in place by the government. Also, you have to have what's called testamentary capacity, which basically means you have to know what you're doing. Next. So how do you ensure that your will is legally binding? To be valid, a will has to be in writing. It has to be signed by the will maker in front of 2 witnesses who also have to sign it. There are also specific clauses that need to be put in every will. There are some exceptions to this general rule, but I wouldn't count on them. Next. So often people ask me what an executor really is. You hear this term a lot, but a lot of people don't quite understand what that means. So an executor is just a person or a company named in a will to settle an estate. They're the people who will deal with everything when you pass away. This is a very important job that is very time consuming and can be quite difficult. So you have to put some thought into who you're going to designate to this role. The executor has many duties, and the skills that they will require depend on the size and complexity of the estate. The main duties of an executor are to make sure your wishes are carried out, to meet all the legal and financial requirements of the estate, to collect and distribute all your assets, and to make your funeral arrangements. Next. So a good executor has to be good with numbers and details. They have to be impartial and able to deal with demanding beneficiaries, and they have to have time for this difficult job. They should also be willing and able to act. They should be trustworthy, and they should reside nearby. So for some people, that could be your spouse, it could be your children, it could be a neighbor. But sometimes those people don't fit all these criteria, and then you may need a professional executor. So a professional executor could be a lawyer, an accountant, or a trust company. and they should be somebody who is competent, who is, like I mentioned, impartial, and can be especially useful if you have ongoing trust to be managed, if you have a business, if you have a lot of domestic or foreign real estate, if you're setting up complicated trusts and foundations. 2 slides, please. If you have a lot of investments that would need to be liquidated, if you have a lot of non-resident beneficiaries, if you have minor kids or beneficiaries with special needs, or if there are other complex family circumstances. Next. So a lot of people wonder, well, just how much is my executor going to charge? Would a professional executor charge a lot? So any executor can charge a fee. Sometimes people will specify the fee right in the will, and if they don't, the executor can charge up to 5% of the gross value of the assets. They also can charge a carrying fee for every year that they have to administer the assets of up to 0.4%. Typically, an executor will charge somewhere around 2 to 3%, and they have to get the permission of all the executors or of all the beneficiaries, or pass their accounts with the court and have the court approve their fee. Next. So the next thing you have to decide when you're preparing a will is who will be your beneficiaries. So your beneficiaries are the persons you name in your will to actually receive your estate. You can leave specific amounts to somebody, you can leave specific things to somebody, or you can divide your estate in percentages, or do a combination of those. You can leave gifts directly to your beneficiaries, or you can have someone hold those assets in trust for the beneficiaries. If you're leaving assets to your minor children, you have to ensure that those assets are held in trust until the child is at least 19 years old. Next. So many of my clients don't have a clear idea of what assets actually make up their estates or why that's important to know. Your will does not deal with all of your property, and sometimes it makes sense to keep some of your assets outside of your estate, because if you can keep some of those assets outside of your estate, those may not be subject to claims from creditors. They may not be affected by wills variation claims, so your good-for-nothing kids can't get their hands on them. And they're not going to be included in your estate for probate purposes, so there won't be probate fees payable on those assets. Next. So there's a few ways to keep property out of an estate, and each has advantages and disadvantages. The first way to keep assets out of your estate is to own it jointly with another person. There's 2 ways you can own property with another person, either as joint tenants or as tenants in common. If you own something with somebody else as joint tenants, then if one of you passes away, your share goes automatically to the other person. If you own property as tenants in common with somebody else, then if you die, your share of the property goes to your estate and the other person keeps their portion. So it's important to know whether property that you own with somebody else is owned as joint tenants or as tenants in common. And if you don't know that, you should find out. Next. You have to be careful with joint tenancy. Whenever someone calls me about adding somebody as a joint tenant on their property, warning bells start going off in my head, because people often don't understand all the implications of this. If you add somebody as a joint tenant on your property, A, you're going to lose complete control of that property. B, you become susceptible to claims from that other person's creditors and that person's spouse if they split up. And if we're talking about your home, if you add somebody onto the title as a joint tenant and that person doesn't live in the home, then you're going to lose the principal residence exemption for that person's half of the property for any future gains in the property. And that loss of principal residence exemption may lead to way more capital gains tax than you actually save in probate fees. Also, if you're planning to transfer property to somebody to avoid wills variation claims, you have to also sign something called a deed of gift, where you confirm that you're actually intending this to be joint tenancy. Because the courts have recently decided that the right of survivorship is not automatic. And if you add somebody on as a joint tenant, if you don't have clear evidence that that's really what you intended, that you wanted that property to go to them, then they could apply to court to have that property yanked back into the estate and divided pursuant to your will. So the takeaway is, before you add somebody onto an asset as a joint tenant, talk to your lawyer. Next. Most life insurance policies, RRSPs, RIFs, TFSAs, and other similar benefit plans permit you to designate a beneficiary right in the plan. The asset then transfers directly to the beneficiary on your death. You can make a beneficiary designation like this directly in the plan, or in the will itself, or when you're talking about life insurance, in a separate insurance declaration. You have to be careful with this strategy if you're leaving funds to a minor or a disabled person. You have to ensure that you also appoint a trustee and set out terms on how those funds can be held. Otherwise, they're going to be frozen for the child until they hit 19, and then they get the whole chunk in a lump sum. So again, before making changes to your designated beneficiaries, have a chat with your lawyer. Next. I'd now like to talk about trust for a couple of minutes. A trust is created by an individual who we call the settlor through a will or through a separate document called a deed or a declaration. Someone is appointed as a trustee and administers the trust. In a will, this is usually your executor, or it could be a separate person. In order to establish the trust, the settlor transfers title to certain assets to the trustee, who will then administer those assets on behalf of the beneficiaries on the terms specified by the settlor in the trust document. Next. Trust can be very useful for tax planning, for managing your family assets for the benefit of your adult or minor family members, or for charitable purposes, and it can be used to protect your assets from the claims of other parties like creditors or people you're trying to exclude from your estate. Next. There's two main types of trusts, inter vivos trusts, which are trusts you make outside of your will, and testamentary trusts, which are trusts within your will. An inter vivos trust can be useful for certain people. Typically, the trust document will create provisions as to how that property is to be dealt with when you pass away. An inter vivos trust will rarely form part of your estate, and can therefore be a very effective way to keep assets away from creditors and away from a child or a spouse that you're trying to exclude from your estate. The trade-off is that these trusts can often be quite expensive to set up, and there may be tax consequences from transferring property to the trust. Next. There are many different trusts that are useful in different situations. Certain trusts are designed to be used in an estate planning situation. One of the most common inter vivos trusts used for estate planning is the alter ego trust, or when it's created by a couple, a joint spousal trust. With this type of trust, if you're over the age of 65, you can transfer some or all of your property on a tax-deferred basis into the trust before you die. This is huge because usually if you roll property into a trust, you pay capital gains tax immediately. With these trusts, you don't. Once property has been transferred into this trust, it's used only for your benefit while you're alive. It's like the Superman to your Clark Kent. So you'd have complete control over the money, and then when you die, the trust specifies who you want it to go to. So that often mirrors the terms of your wills. Because the property is now outside of your estate, like any other type of inter vivos trust, there will be protection from your spouse and your kids and from other creditors. So this can be a very powerful tool if you think your children may challenge your estate. It's also very useful for avoiding probate fees. So if, for instance, you have a large, if you have a house on the west side worth several $1 million, this could be useful to avoid probate fees on that property. Next. You may also create a trust in your will to take effect once you pass away. In this slide, I've listed a few common types of trusts we see in wills, but the trust possibilities in your will are really endless. With a spousal trust, you can hold property in trust and give your spouse the income and possibly capital from that trust during their lifetime. And then upon your spouse's death, the rest of the property would go to some other beneficiary, often your kids. This is particularly useful in blended family situations because you can have your assets all held for your new spouse and used for them, and ensure that some of the capital ends up going to your kids when your spouse passes away. Often trusts will be put in your wills to care for your children until they hit a certain age, so they don't get a big fat check when they're 19 to run off to Vegas and blow in the slots. Some people in their wills will also put in trusts that allow your trustee to decide who will receive your assets and when they will receive them. This is called a discretionary trust. Next. I wanted to point out a particular trust that we see quite often that can be done either in your will or outside of your will, and that's something called a discretionary trust for persons with disabilities, or a Hansen trust. Lately, I've had many clients come in who want to leave money to a child or to a grandchild with a disability. This has to be handled very carefully to ensure that the disabled person's provincial benefits are not affected. The discretionary trust can be used for that purpose. They're also quite useful for dealing with kids with drug problems or alcohol or substance abuse issues, or those who otherwise just can't handle money. Next. So I want to talk for a couple minutes now about what happens if you die without a will. So if you die without leaving a valid will, the administration and distribution of your estate in British Columbia is going to be governed by the rules set out by the province. The province has set out rules that deal with both the administration of your estate and about who's going to receive your property and about who is going to handle your kids when you pass away, who the guardian of your kids will be. So in British Columbia, when you pass away, your estate has to go through one of two processes, either the probate process or the administration process. And both are processes whereby the court rubber stamps who's going to be dealing with your estate. So if you die without a valid will, or if your executor is unable or unwilling to act as your executor, then your estate has to go through the administration process, and your property will be distributed the way that the government has set out. You'll have no say whatsoever in how your assets are going to be dealt with. If you happen to die without any relatives, then your estate will pass to the government. In the administration process, next slide, someone, usually one of your next of kin, must apply to the court to be appointed the administrator. If nobody is available to apply, then the public guardian trustee will be appointed by the court. Though the administration process is similar to the probate process, an administrator does not have the same powers as an executor, and also doesn't have the ability to start acting right away when you pass away like an executor does. So it can be more time consuming and can also be more costly than probate. Next. If you die without a will and you haven't appointed a guardian for your kids, and there's no surviving parent with legal custody, then the public guardian and trustee and the superintendent of family and child services become the guardians of your children. In order for a relative or a friend to take over, they'd have to apply to court, and this can take a long time, during which time your children will be wards of the province. So if you have kids, this alone should convince you to do a will. If you have grandkids, this should convince you to get your kids to get wills. Next slide, please. Just before we talk about death taxes, the last thing I want to mention about dying without a will is that if you do die without a will, the government decides who gets your money. If you have a spouse, it will go to your spouse. If you have a spouse and kids, it's divvied up between your spouse and your kids, and not necessarily the way that you would want it to be. If you don't have a spouse and kids, it goes to your parents. If you don't have parents, it goes to your siblings. If not siblings, nieces and nephews and cousins. And if there's nobody else, it goes to the government. So a large part of the estate planning process involves making sure the government receives as little of your money as possible. Next. The first cut that the government tries to take is in probate fees. So when an application is made to court for probate or for letters of administration, then a fee is payable, and it's 1.4% of the gross value of your estates. And nobody wants to pay anything to the government, but 1.4% is still a fairly small amount. But you can avoid that by holding assets jointly, or with a designated beneficiary, or in a trust outside of your will. Next. Though there is no direct estate tax in Canada, death certainly does lead to taxes, because death triggers a variety of additional income taxes. Taxes may arise as a result of payments from your RSP, pension payments, annuities, and certain life insurance payments. Taxes may also arise as a result of the deemed disposition rules in the Income Tax Act, which provide that when somebody passes away, all of their capital property is deemed to have been sold, and you have to pay tax on all that capital property as of the date of your death. Next. As your death may result in a significant income tax burden being borne by your estate, it's prudent to obtain tax advice in conjunction with the preparation of your will. When your lawyer helps you create your estate plan, they will look at all the different ways taxes arising as a result of your death can be avoided. This can include, next slide, the principal residence exemption to capital gains tax on your house. Next slide. Capital gains exemptions for shares of a qualified small business corporation. Next. Transferring capital property to a spouse to avoid capital gains tax. Next. Estate freezes for business shares. Next. Income splitting using trusts. Next. Certain beneficiary designations for RSPs. Next. And for RIFs. Next. And leaving funds to charity. And I went through all that very quickly because we don't have a ton of time. The takeaway is that when you go see your lawyer to deal with your estate plan, they're going to look at all these different tools that are available depending on their circumstances to try and minimize taxes. So, Linda, what are we talking about next?
Thanks, Mark. That was a lot. Went through that really quickly. So
luckily,
now
we
talked
this
about
recorded so people can review it later.
Right. So wills are important for after we die, and death is a definite. We're all going to go there at some point. We don't know when, but what happens if ill health prevents us from making decisions? Now, we don't know if that will happen in the future, but it's a possibility. So how do you ensure that someone you trust is chosen to act for you and to look after your financial, legal affairs, and your medical decisions if you're not able to?
Yeah, so in British Columbia, there are 4 documents that can be prepared to ensure you have some measure of control over what happens to you when you can no longer make decisions for yourself. The most common is the enduring power of attorney. With a power of attorney, you can give another person the power to deal with your financial affairs for you. In other jurisdictions, sometimes there are powers of attorney for health and personal care as well. In British Columbia, we call those representation agreements. Powers of attorney are just for financial affairs. And they can be either for general purposes or for very specific purposes. You can have one attorney, you can have more than one together, you can have one and then alternates. It's totally up to you. Power of attorney will last until you pass away or you rip it up or somebody is appointed by the court to be your guardian. So with the power of attorney, you're giving somebody the power to deal with all your financial assets. And you've got to be very careful as to who you choose, because once you become incompetent, you can't watch over that person anymore. So you would lose your ability to supervise them and stop them from taking all your money and running off to Mexico. So it's a very powerful tool. And like I said, you have to be very careful with who you appoint. Next slide. So people often wonder what happens if they don't have a power of attorney. And some people are under the mistaken impression that if they have a spouse, their spouse can just make decisions for them. And that's not the case. If you have a joint account, with your spouse, then that account your spouse may be able to pay for things in the short term using that joint account, but they're not going to be able to sell your house. They're not going to be able to borrow money. They can't deal with your taxes. They don't have the right to make any important decisions for you without a power of attorney. If you don't have a power of attorney and become incompetent, then somebody is going to have to apply to court to become what's called your comité. And a comité is spelled committee, pronounced comité, nobody knows why, but it's basically a court-appointed guardian. The procedure for applying for a comitéship is very costly, it's very time-consuming, and we try to avoid it if we possibly can. So I would certainly suggest that you prepare a power of attorney. Next. As I mentioned, powers of attorney for financial matters, in British Columbia, we have something called a representation agreement that you can use to appoint someone called a representative to help you make health care decisions and personal care decisions. It can cover everything from taking you to the dentist to deciding where you're going to church, who you're going to be drinking with, and where you're going to be living, and the decisions you want made at the end of your life. So that's what Americans call a living will. And you can insert those living will provisions right into your representation agreement. You can structure the representation agreement so that it starts right away, or so that it comes into effect at a later date, like when you become incompetent. Representation agreements are useful if you have, let's say, a bunch of kids and you want to appoint one or more of them to make decisions for you. It's even more useful if you don't have a spouse, you don't have kids, and you need to appoint some other family member or friend to make decisions for you. Next slide. Like with powers of attorney, you can appoint one person or more than one person. You can appoint alternates, and you can also appoint a monitor to watch over the representative and make sure that they're doing what they're supposed to be doing. The representation agreement will last, again, until you pass away, you rip it up, or if it's your spouse, if you get divorced, or if you pass away, or if a comitatus is appointed by the court. Next. So what happens if you don't have a representation agreement and you lose capacity? The government has decided who can make temporary emergency decisions for you. So if you have no spouse, and let's say if you have a spouse and you were hit by a bus and you're in a coma, your spouse is going to make temporary decisions for you. If you don't have a spouse, one of your kids can make decisions, and that can lead to arguments amongst your kids as to who's going to be making those decisions. If you don't have kids, it'll be your parents. If you don't have parents, your next closest relative. If you don't have anybody who can help you, then the public guardian trustee could step in. But these are only for temporary measures. If you don't have some catastrophic accident, and let's say you're just slipping into dementia, that's not an emergency situation. And if you don't have a representation agreement set up, then somebody would again have to apply to court to be accommodated to be able to make decisions for you for your day-to-day needs, where you're going to be living, who's going to be assisting you with your care. The next paragraph. If you don't want or can't make a representative, let's say you don't have somebody you would want to appoint, you still can sign something called an advance directive, which is basically a living will. With your advance directive, you can indicate that you refuse in advance treatment that is therapeutically useless. So it's basically deciding that you don't want any heroic measures taken to keep you alive. It's certainly not as useful as a representation agreement because it's only for that one last day of your life. Whereas with a representation agreement, that would deal with all your health and personal care over potentially a long period of time. And that's basically what I had to say about it. Next slide. So are there any questions?
So do we have questions to pose?
We do have questions, and my apologies. I was just getting myself up on camera here. They're coming fast and furious. So thank you to the audience for sharing your thoughts and asking your questions. I'll start from the top, from the most recent ones. I think they pertain to what we've just been discussing. So first off, is the representation agreement mandatory to make decisions for elderly parents? And perhaps I will pose that to Mark first off here.
Yeah, so it really depends on the decisions that we're talking about. So like I mentioned, if, let's say, heaven forbid, your parent has a stroke and they're in the hospital and you don't have a representation agreement, well, the doctor is going to be asking the kids as the temporary emergency decision maker what decisions they want made. But in most situations when dealing with your parents, it's not an emergency. And then, yes, a representation agreement will be required. And if you want to decide that it's time for your parents to move to a care home, the care home is going to be asking for the representation agreement to ensure that you have the ability to make these decisions for your parents. And if you don't have them, then sometimes because people don't know the law, maybe they'll let you make some decisions, but eventually you're going to run into somebody who requires it before you're able to do something, and that's when you're going to have to go to court and start the comitate process.
Okay, great. Thank you for that, Mark. This next one is actually an interesting one, and I think it's no secret that the Lower Mainland is very multicultural. So I'll ask the question. There are many families from overseas in the Lower Mainland where a foreign guardian who is not Canadian nor lives in Canada is the only guardian option available for one's minor children. What risks should one mitigate or consider in the will, and how should they be mitigated? When when would they need to move to another country in the event of the parent's death, and perhaps what considerations should be made in the will or the planning to ensure the estate benefits the children? Lots in there. Happy to repeat the latter questions. Mark, perhaps this is a good one for you,
Yeah,
and Linda, feel free to expand.
yeah. So I mean, there's a lot there. You know, we run into this every once in a while where somebody is somebody's appointed as guardian who's not in the country, and you know, it's really, there's not too much that you can do in the will with respect to the guardianship to make that any easier. You know, that person is going to have to get on a plane when you pass away, and you know, and come over here and deal with that kid. And you know, they have been appointed guardian. They are now the guardian for that kid, and they will have the right to take them out of the country. But you know, they're going to have to deal with all the immigration stuff for their own country. You know, showing that they have the right to do this. So every country is going to be different, and you know, it's really not something that you can do ahead of time. It's just something that will have to be done at the time. And there may be a delay there where they have to be in the country here or appoint somebody to assist that kid. You know, just like if I you know, ask my my sister to watch my kid for a couple of weeks while I go on vacation or something, they're my temporary, you know, they're temporary guardian for the kids. I'm still the guardian. I still have control. I've just allowed them to temporarily watch over the kid, and that's often done when somebody is overseas until they can come and take custody of the child. With respect to funds for the child, you know, the will maker is going to have to really think about who they want to appoint as their executor, as the trustee of those funds, who will make the most sense, given that the child may now be living in another country. And you know, this is something that you should talk to your lawyer about, but there are definite considerations about appointing a foreign person as your executor, as your trustee, because that can lead to your estate becoming resident in that other country, which can have significant tax consequences. So it's more than we can talk about today. It's a pretty big question to talk to your own lawyer about.
Yeah, thank you, Mark. And I was going to say it's a complex subject, and I think we've heard that a few times today. Definitely worth having conversations ahead of time and planning. I think that's another message. The questions keep coming. Thank you, audience. This is fantastic. My next question is, who is considered a surviving spouse? Would a person who has been living separately from you, perhaps for a few years, but with no separation agreement in place, are they still considered a spouse?
Okay, so for estate planning purposes or for estate administration purposes, the second that you separate from somebody, they are no longer considered your spouse. And that's for estate planning purposes, but not necessarily for family purposes. So in the rare situations where this occurs, so let's say on my deathbed, I separate from my spouse, they could still make a claim against my assets using the family laws, but not necessarily using the estate laws. But one interesting thing is that it is possible to have more than one spouse in British Columbia. So for instance, I could have my wife, who I'm married to, and maybe there's another lady that that I have a relationship with on the side and have a spousal relationship with, and both of them would be considered a spouse. So you can often have conflicts there, and often that doesn't come out until somebody's passed away, and then you have massive fights that makes lawyers very happy.
A spouse can be of either gender as well.
Of course, but in my situation, it would be my wife.
Great, thank you, Mark. Linda, I'll pass a question over to you, and this is more of a banking, sort of financial affairs question, and I think something that we see a lot across financial institutions. So the question is, if I add someone to my account, joint onto my account, is that a great way to just avoid probate?
Yes and no. That's a complicated question, as Mark had alluded to earlier. So with spouses, it's usually a pretty good way of dealing with things. You can pass things outside of your estate without too much hassle, and the spouse can continue to access that account. With children, it becomes more problematic with adult children, and courts have found that they don't accept that automatically as a real joint tenancy, as Mark had said already. So it could be considered as a trust, or it can be considered as some other relationship or arrangement with them. So if you want to have it as a true joint tenancy, whether you want that beneficial interest to transfer immediately or later on death, then as Mark said, a deed of gift should be included as part of that planning process so that you specify what your intentions are. And if you don't do that kind of thing, then there could be difficulty in interpreting what your intention was, whether there might be tax issues, tax consequences because of that transfer or into joint tenancy. And also there might be difficulties among the family if there's misunderstanding about what the intention was there.
And there's also
so not an easy question.
Yeah, and there's also the flip side too. Sometimes people add one of their kids onto their account with the intention that that kid would share it amongst the other children. And in that case, we typically suggest that they have that child sign a declaration of trust, confirming that they're holding it for the other children, so that when you pass away, they can't try to claim that that money was really just supposed to be for them and screw over their siblings. So, either way, just more planning needs to go into place there than just going into the bank, going into the credit union and saying, I want to add this person onto my account.
Yeah, and the same applies for property. A lot of people want to do that with their property as well. Same thing applies. You do need to consider what the intention is and document it correctly.
Excellent. And that was one of the other questions we had pertaining to real estate specifically. I think that's another hot topic considering the real estate values in the Lower Mainland that we see. Linda, maybe as we're calling on you to answer some of these questions, I wonder if you could just expand on some of the services and the advice that you provide our members at Vancity.
Yeah, that's great. So I am part of the Sustainable Wealth management team at Vancity, particularly the advising part. So my team includes financial planners, but my role is primarily estate planning. So I do speak with members. They're free to come and make an appointment with me for consultations. I'm doing that over the phone currently, and we discuss all sorts of issues about their planning and their estates and what their needs are, and just answer questions, help them to understand the basics of estate planning, much like what we're doing today, but on a one-to-one basis, and to look at what their needs are and hopefully to steer them in the right direction. I don't give legal advice. I don't do that. I don't give tax advice, but I can give overall general information about those issues, and I can point out where there might be some issues or questions they might want to pose to their legal advisors or to their tax advisors. So hopefully by talking with me, they can prepare a little bit before they go to see the professional advisors and have their information all prepared and set up and their wishes together as well. There's lots of information also on our website that people can access if they want to go there.
Fantastic. Thank you, Linda. Mark, maybe a bit of a cheeky question here, but what is the difference between a lawyer and a notary in the will preparation process? And when might you use one versus the other? What sort of situations would
Sure.
you consider?
Yeah, I mean, it's there's a few main differences. I think the most important is that notaries are limited in the complexity of their wills. So a notary cannot put a trust into a will, and a lawyer can. And for a lot of people, trust will be required. And if you go see a notary, they can't do that. So they'll either have to, you either have to make a simpler will, or you'll have to restart the process with the lawyer. But if you have a very simple situation, then maybe a notary would be fine. The cost is going to be very similar in many cases between a notary and a lawyer, though when you are doing much more complex wills with a lawyer, that it might be more expensive. But yeah, that's the main difference.
Wonderful. Thank you. And apologies for the cheekiness there. I think it's good to highlight. Absolutely. Linda, I'm going to switch back to you. And this is, again, more of a banking financial question. In terms of the beneficiary on the account, if the contract on that RSP, for example, shows a different beneficiary than what is stated on the will, how is that handled?
Okay, so when you're making beneficiary designations in your will, you do want to make sure that it is specific. So it would have to refer to that particular account or product that you're intending to name the beneficiary for. So then the general rule would be whichever was the latest designation would usually be in place. But it still could be confusing if it's not clear. Or if you don't notify sometimes the financial institution, if you're intending to change things, then it can get confusing. So you do need to take care in making sure that those things are all coordinated and clear.
Yeah, excellent. And it's not always possible, but definitely having these conversations and having these things clear ahead of someone passing away certainly is of benefit to survivors. Yeah, thank you, Linda. Mark, back over to you. And this is more of a business side of the question, so I think right up your alley. So the question is, if you have a business and this business has an insurance policy, and the business account has funds in its demand account, you perhaps want to give a share to your son. So, it's rather specific here. Are there any taxes at your death? Are there taxes at your death that would perhaps affect this share going to the son? Yeah, sorry, that is it. My apologies for the garbled question
that's
there.
Fine. So, certainly, let's say I have a business that's worth $1 million. And when I started the business, it was worth nothing. Right? That's a gain of $1 million. My shares in that business are worth $1 million, or have had a gain of $1 million. And the presumption is that when I die, capital gains tax will be payable on those shares. Now, there may be some ways to mitigate that, depending on the type of company. There might be a capital gains exemption for a portion of it. If you want to transfer it to your spouse, you can defer that gain. Maybe you've thought about doing something like an estate freeze to transfer it on to the next generation. But if none of those things work, capital gains tax will have to be paid before that share will be transferred on to your child.
Okay, excellent. Again, getting into some specifics here for you, Mark, and this is a good question, I think, on trust. So what are the cons of an alter ego or a joint spousal trust? And why wouldn't everyone with assets undertake this measure? And even if you're able to share, what is the cost? I know that's that's a variable there.
Yeah, so that's the big con, is the cost, right? I would think conservatively, you're looking at $5,000 to set one of those things up. At some firms, it may be significantly more. You could be looking at the $20,000 to $30,000 range. And so you have to make sense that you have to ensure that it makes sense to create it, given how much the savings may be, right? If your only goal is avoiding probate fees, you have to have $3 or $4 million in assets at least to make that cost worthwhile. Another drawback is that you're going to have to do tax returns for it every year. There probably won't be tax payable. The income would flow down to the beneficiary, but you still have to do the return. So a bit of a pain in the butt administratively every year. So those are the big drawbacks. But also they're complex, and they're only available for people over 65. And as you get much older, that complexity is not necessarily great in your life. You may be trying to simplify things instead of making your life more complicated by having these complex trusts. So for a lot of people, it's just not worth the effort, given that the probate fee is so small compared to the size of your estate.
And then also, yeah, the deemed disposition still applies also while it's in the alter ego trust. So whether you own it individually or in the trust, there's still a deemed disposition and capital gains.
Yeah, when you pass away, eventually. But we also have to look at balancing it out against the other considerations for adding the assets in. If you were adding the assets in to avoid claims from one of your children or your spouse, then regardless of the cost, it may still be useful. It's a powerful tool for doing that.
Fantastic. And Linda, maybe just to clarify your previous point, you'd mentioned deemed disposition. Can you expand on that for our audience?
Sure. So when Mark was talking about the taxes, we have additional taxes on death because CRA imposes what's called a deemed disposition. So it's treated as if everything we own at the time of our death is sold. So if there's any unrealized capital gains on your assets at that time of death, then it's triggered in the year of death and you have to report it at that time. So that's one of the big tax issues on death.
Great, thank you for that. So we were talking about property and maybe not specifically real estate earlier, but if there is property outside of BC, how would that be handled? Is that through a secondary will? Are further considerations? And I think in reverse, if someone has a will outside of Canada but has property within BC or Canada, maybe Mark, I can direct that to you first, and Linda, feel free to jump in if.
Yeah, one of the nice things about our estate laws is that they provide for the ability to have more than one will. So some people in Canada who have businesses will choose to have one will that deals with their business assets that don't necessarily have to be probated, and another will to deal with their assets that do have to be probated to lower the probate fees. But we also do see dual wills to deal with property outside of Canada. So let's say I have a house in the UK and I have the rest of my property here in Canada. I may have a will done in the UK just to deal with my UK property and another will here in Canada to deal with my other property. What I have to be careful about, though, is ensuring that those two wills don't accidentally revoke each other. Right? So you have to do those wills in conjunction to ensure that that it's done properly. If the other part of the question is it has to do with when you go through probate. So if you have two wills, then if you pass away, probate can be done concurrently. So you can go through probate in, let's say, England, and you can go through probate in Canada. But if you only have one will that deals with all your worldwide assets, you first go through probate in the place that you reside and deal with the assets there. And then you kind of reprobate in all the other places that you have assets. So it just means more delay in administering your estate, but it's fairly simple to do.
Okay, excellent. Thank you. And Linda, anything to add?
No, those are certainly strategies that people can use, as Mark said, for business assets as well as for assets outside of the country. And there are reasons for doing that, but they are more complex issues that need to be dealt with a lawyer with advice also.
Yeah, great. Thank you. A couple of more questions here, and thank you again, audience. Some really, really good, thoughtful things coming in here. Passing away without a will and pertaining to guardianship specifically, and this one is maybe relating specifically to infants. define infants. You know, is this any child under a specific age? Is that 18? Is that 19? Mark, you're nodding, so I'll pass over to you.
Yeah, so infant is the legal term for a minor child. So anybody under the age of 19 is technically an infant.
In BC.
Okay.
In BC, yeah.
Good. And again, an important point there, BC specific. Thank you. So last question here. And the question is pertaining to being a permanent resident. So can you make a will or appoint an executor, a power of attorney, a representation agreement as a permanent resident?
Sure. Yeah, that's not a problem. Anybody can make a will if they have property in a jurisdiction, right? So it would make no sense to do a will here if you don't have any property. But once you have any assets, you can do a will in that place, whether you're a legal immigrant, a non-legal immigrant, or anybody else. And you can, like I mentioned before, you can have multiple wills in multiple different jurisdictions. So that is not a problem at all. With respect to powers of attorney and representation agreements, it is useful to have those. You may have to have powers of attorney in every jurisdiction that you have assets, because they are specific to the jurisdiction that they are created in. So BC power of attorney may not be useful anywhere else in the country, in the world, other than BC. For a representation agreement, you're going to want to have that in this jurisdiction that you spend the most time, because that's where health and personal care decisions are going to be made for you.
Okay, fantastic. I do want to point out that Linda for Vancity, and she described her services quite well earlier, is certainly available to meet members, and that is available through our appointment booking service online. I'll wrap up our questions at this point, but I really want to thank our special guest, Mark, and our in-house specialist, Linda, for their time today. Kristen, I will pass over to you to wrap us up.
Great. Thanks, Graham, for moderating. And thank you, Mark and Linda. Lots of great questions and a lot of invaluable information that we tried to squeeze into an hour. And I think sometimes it could be not enough time, but we want to respect everyone's time. And hopefully you can glean whatever information necessary to help you along the way. But based on the great questions, there are a lot of factors, considerations when doing your estate planning. So this can be very daunting and at times very overwhelming. And really, Vancity is here to guide you. So again, just to repeat, I encourage all of you to reach out to Linda. She can get you started on the path that is right for you and your family. And she will then refer off to those like the lawyers like Mark in terms of the expertise needed. So as a reminder, before we close off, we will be sending a link to this recorded session early next week. We do have 3 more webinars scheduled on the following topics: investing in what matters to you, so building your wealth and a better world with socially responsible investing; retirement planning, when to start. I don't think you can start too early. And based on current market conditions, really, what does this current market mean? So getting updated on the start of, on the state of the economy, and learn why timing in the market is not necessarily a tactic, but time in the market is certainly something you need to consider. So if any of these topics interest you, please register. And really, again, we want to thank everyone for taking time out of your busy schedules on this gloomy, rainy, typical Vancouver weather day, and just enjoy the rest of the day. Thank you.